Welcome to the AGEWELL Summer Institute. My name is Laura Tamblin-Watts, and I am profoundly sorry not to be there in person today. I was grounded on the tarmac in Israel, and so while I was very much hoping to be there in Banff personally, I know that you will enormously benefit from having Professor Kirsten Kramer, who is an expert in law and society, be able to guide you through today's sessions. We're going to take apart the 90 minutes that we have together in a couple of different ways. The first part of the time we're going to spend together, I'm going to talk about consent capacity and advanced care planning. And when we talk about consent capacity and advanced care planning, we will discuss the laws across the country, because I know that many of you will come from different jurisdictions, and what we know is that, of course, the laws in each jurisdiction are a little bit different, but there's some commonalities that we can say across. And so I think that you've got probably the PowerPoints in front of you, and I will be referring to the PowerPoint slides as we go. So the first slide is, what about mental capacity? So when we come in, we're talking about mental capacity. It's really important to know that capacity is not a medical issue, although it's quite a surprise quite often when we're talking to our medical professionals, because they often do think that mental capacity is a medical issue. It's actually a legal determination. So if you think about who determines capacity, ultimately it would be a judge who determines capacity. Although, of course, only a very small, indeed a fraction of issues will ever go before a court. So how then do we determine mental capacity if you're not a lawyer, you're not a judge, or indeed an expert psychogeriatrician? Well, actually, we're always judging people's capacities, really every day. If you're talking to somebody and something doesn't quite jibe, you think that maybe they're drunk, or they're high, or they've had a trauma, or they've just been in hospital, or they're on antibiotics, or they've got a UTI, something has happened and they're not their usual selves. We're always trying to assess whether or not that person has mental capacity. And when we look at the laws of mental capacity, really it's one key test, which is easy to say and hard to in fact determine. It's the ability to understand information and appreciate the consequences. So let's take that apart a little bit. We know that anyone can lose or gain different kinds of capacity at any time. But imagine, if you will, you're going across the street, and on one side of the street you're perfectly fine, you're capable, everything is going very well, and then you get hit by the bus. And then the other side of the street, hit by a bus, you're in a coma. Really, that's the only time that you go from a legal capacity to a legal incapacity. Otherwise, you're really looking at turning the dial up or down. So a person can be more or less capable depending on certain things. Now, if you take a particular instance of having too many drinks, you can be quite capable at 1 to 2 drinks and quite incapable of many things at 6, 7, or 8 drinks. And similarly, what we know is if you have dementia, you may have some form of sundowning, or you may have sugar imbalances if you've got diabetes, and this can affect your ability to understand and appreciate. But let's take those two things apart, because you have to be able to do both. So the ability to understand information means that you have to be able to comprehend what the information means, and you need to be able to figure out the what-ifs around that information. And to appreciate means you need to be able to reason and compare that information in the context and be able to figure out implications of that. So again, let me draw that out a little bit. You can understand information but not appreciate it, and then you'd still, quote, fail that test of capacity. There was a person that I was working with who had a full encyclopedic knowledge of schizophrenia. So if you asked him about schizophrenia, he could tell you chapter and verse. At that time it was the DSM-4, now it would be the DSM-5. And if you asked him about it, he could tell you all of the implications, all of the information, all of the medical facts associated with schizophrenia. So he understood schizophrenia. If you asked him about his schizophrenia, however, he would tell you that he didn't have schizophrenia, which of course was not true. He had schizophrenia and indeed had had a number of psychotic episodes for many years and had been hospitalized according to that. So he understood information but couldn't appreciate that it had to do with him. By contrast, my grandmother, who at 94 had some significant dementia, also needed insulin sometimes to regulate her blood sugar. So she would see the nurse come through with a needle, and the nurse would come through to give her her insulin injections. And my grandmother would do this. She could appreciate that somebody was going to give her a needle, but she couldn't understand why she needed that needle. And even though for years and years and years she'd been having insulin shots or other forms of insulin, she could no longer understand the information. So again, she'd fail the test. You have to be able to understand and appreciate. What we also know is that people make significant assumptions about mental capacity of older people, and in many cases just jump to the idea of having a younger person or a decision maker on behalf of that person, such as a power of attorney, which we're going to talk about in just a few minutes. But what we know is that most older adults will be able to make their own decisions, and when we are talking about decisions, we have to be clear on what kind of decision we're asking. So you're going to hear, and I'm turning the slide now, me constantly ask capacity for what? So you see on the next slide it says capacity continuum, and you have a scale of capable and incapable, which indicates that people can become more or less capable at any time. So you can gain capacity if you get better after, for instance, you've had some anesthetic. You can gain capacity if you've taken sulfa drugs and some cranberries and you've improved from a urinary tract infection. You can become more capable if people are there to help you, provide you information in a way that you better understand it by providing better context or using smaller words or using words that would make sense to you in terms of your cultural context. And you become more or less incapable at the same way. If anyone's ever had a terrible shock or you've been in a car accident and you can't quite process the information that's happening, you become less capable. If you've ever been in a situation where you can't hear from all of the noise, you are less able to understand and appreciate the information. So capacity is a legal test and it's domain specific. So moving to the next slide, which says powers of attorney, 2 domains. I want to talk about these 2 domains more broadly and then break them out across the country. So we are here in lovely Alberta, and Alberta has its own laws on this. Next to us, of course, is British Columbia. They have their own laws on this, north of us, east of us, and so on. But we can talk in general, and then I can provide you with materials which you have to help provide you with the specific information for whichever jurisdiction that you're from about the different specific laws in a narrow way around decision making and capacity. So this slide talks about 2 kind of broad areas: the ability to make decisions or have someone make decisions for you around health and personal care. So that's what we consider, the healthcare choice or how somebody is going to live their life. It has things to do with their bodies and their circumstances. We have also the domain of property. And when we're talking about property, we're not just talking about physical property in the sense of it being land that you may reside on or that you may own. It means really everything that you have. So it's your computer, it's your necklace, it's your car, it's your RSPs, it's anything to do with the stuff that you have. And when we're talking about decision making in this area, it also is important to know that the way that we organize our laws is around kind of those 2 broad areas. So you can have a decision maker, which we're going to talk about just for a second, and it can be the same person for both of those domains, but it's under 2 separate documents. You can have 2 different people, or you can have entirely different schemes, but you have to cover off both. So moving to the slide that says planning for future decisions, you'll see that if you're a capable adult, you get to decide. And if you're an incapable adult, Somebody else will decide. That's a substitute decision maker. And as researchers and as health professionals or as engineers or as people who are trying to get instructions, we often need to be able to receive some kind of decision, whether it's a decision to participate in a study, whether it's a decision to have some type of e-tag put on you, whether it's a decision to have some type of nano implant, whether it's a decision to sell your house, whether it's a decision to have insulin. Whatever those decisions are, they need to have either a capable adult make those decisions, or if they're incapable, hit by that proverbial bus, then it's going to be another person. Someone else will decide. And we're going to talk about how we know who that is in each jurisdiction. But take a minute first to challenge the idea that if you're a capable adult, you get to decide. First of all, in a number of jurisdictions, and I'll just pin out Ontario as one of them, there's not a specific age of majority for health and personal care decisions. In other jurisdictions, and I'll pull upon British Columbia as an example, there is a particular age. You have to be over the age of majority. And that's why some of those times you see those cases where people who may not want blood transfusions, perhaps Jehovah's Witnesses, will flee from jurisdictions like British Columbia to jurisdictions like Ontario. Because in Ontario, all you have to do is prove that you're a person of no particular age who understands and appreciates the consequences of their actions with regards to a healthcare decision. Indeed, there were a pair of Supreme Court of Canada decisions that went up a couple of years ago, and they were both cases that involved 11-year-old girls, and both cases that involved medical treatment that would have significant impacts on their quality of life and their chances of living. And in one of those cases, the 11-year-old girl from Ontario was deemed to have the ability to understand and appreciate, and she chose not to have conventional Western medicine. She also died. On the other case, it was a person who was the same age, 11 years old, and she was deemed not to have the ability to understand and appreciate the implications of her decision, and she was given treatment, and an adult made the decision for her. So when you're capable, you decide, but it's important to be clear about whose capacity and in what jurisdiction. We have some resources for you that can help you better understand in your jurisdiction what the rules are. That line in between is really where the big yellow buses hit you and you fall into a complete coma. And that's the idea of where somebody else decides. But as you can see, and as you know from your practice area, very often capacity is more of a fluctuating state, or it's something that's quite gray, particularly in the areas of things like cognitive impairment pursuant to a dementia. So let's take the next slide, and we're going to talk a little bit about the kinds of substitute decision-making documents you can make. People use the term powers of attorney, and in general across the country that is what they're called. But you may also know the terms advanced care planning. In British Columbia or the Yukon, you may know the term advanced directives. In some jurisdictions like Nova Scotia, you may use the term of healthcare directive. All in the end, what I'm going to talk about is the idea of a domain where decisions are being made about health and personal care, and you're appointing an other capable adult to make those decisions for you. The other area we'll call a power of attorney for property, and most jurisdictions call it that. I should just point out that in BC and the Yukon, they're called representation agreements for health and personal care decisions, and a narrow piece of the financial decisions can also be done by representation agreement. But for the purposes of this talk, broadly we'll talk about powers of attorney for health and personal care, and on the other hand, we'll talk about power of attorney for property, with the proviso that in your jurisdiction, they may be called something slightly different. As you can move to the next slide, you'll see where it says a general power of attorney. Well, powers of attorney used to be the only way that you could actually pay something for something else. So when I had to rebook my flight and I was at the airport, I was able to quickly and easily use my iPhone. I plugged my credit card into the iPhone, and I had the choice of Interact, Visa, Apple Pay, or PayPal in order to confirm my Expedia account. But 20 years ago, when people didn't have credit cards, because most people in the 80s still didn't have credit cards, if I was going to go pay for my grandmother's groceries because she had some physical frailty and it was difficult for her to